Good morning, everyone. We're going to go ahead and get started. I want to welcome you to day 2 of our hearings as part of the 1201 rulemaking for this year. My name is Susie Wilson. I'm the General Counsel of the Copyright Office. Before we get started on the hearing, I want to go over a couple of the logistics that will be familiar with for those who have participated in the past. My colleagues on the government side will be posing specific questions to those panelists who are here with us today, representing both the proponents and the opponents of the proposed class. We will call on those who want to respond to the questions. Some of them may be posed specifically to particular individuals or organizations. Please use your raised hand feature on the Zoom to indicate that you would like to respond to a question. If that for some reason is not working, we also accept physical hands and we can watch for those too. We have a lot of topics to cover today, as you might expect. We ask that you try to keep your answers very focused, that your responses focus on the question asked, and that you keep your comments brief. In addition, today's event is being live streamed and it's being both recorded as well as transcribed by a court reporter. The video and transcript will later be posted on the Copyright Office website. So we ask that everyone speak clearly. Please mute your audio when you are not speaking, which will make it all much easier for our court reporter friends to be able to capture everything said today. Finally, I want to let everyone know, both those listening in today as well as the panelists, that Thursday afternoon we will be holding an audience participation session for everyone. You can sign up to participate in that session using the link that will be in the chat. We ask that remarks in that session be limited to about 3 minutes for public participation, but you can address any of the classes from this week. Today's hearing is, again, Class 3, which is Motion Pictures and Literary Works, Text and Data Mining. Before we begin, I'd like to first invite my copyright colleagues to introduce themselves. And Brandy, why don't you start us off?
Hi, I'm Brandy Carl.
I'm Joanna Blatchley, an attorney advisor.
And I'm Brittany Lamb, also an attorney advisor.
We're also joined today by a colleague of ours from NTIA. And can you please go ahead and introduce yourself?
Absolutely. Good morning. My name is Rafi Goldberg. I'm a senior policy advisor at NTIA.
Great. Now I'd like to invite both the proponents and opponents of the proposed class to introduce themselves. We're going to start with the proponents. And when you do introduce yourself, please do also identify the organization you're representing here today. And since we have a number of folks on behalf of one organization, can we start with those who are here on behalf of the Authors Alliance?
Sure. Good morning. I'm Dave Hansen, Executive Director of Authors Alliance.
Good morning. I'm Emily Sherwood, Director of Digital Scholarship and Studio X at University of Rochester River Campus Libraries as part of Authors Alliance.
I'm Eric Stallman. I'm the Associate Director of the Samuelson Law, Technology, and Public Policy Clinic, representing Authors Alliance.
Good morning, I'm Christian Howard-Sukil, and I'm a clinical student attorney at the UC Berkeley Samuelson Law, Technology, and Public Policy Clinic, representing Authors Alliance.
Good morning, I'm Judy Huang, law student at the Samuelson Clinic at UC Berkeley, representing Authors Alliance.
Hello, my name is Matthew Tongun Shaw. I am also a clinical student with the Samuelson Alliance, Samuelson Clinic, representing Authors Alliance.
Did we get everyone on behalf of the Authors Alliance? All right. I'm going to then turn to the Library Copyright Alliance.
Hi, I'm Jonathan Band. I'm here on behalf of the Library Copyright Alliance, and I'm 6 hours ahead of DC. I'm here in Geneva for the meeting of the Standing Committee on Copyright Unrelated Rights. So I will try to keep more awake than our former president at his criminal trial.
So for you, I should have said good afternoon. Sorry, I thought I had the whole group in the morning time. And then Mr. Bell and Mr. Bauman, can you introduce yourselves?
Sure. I'm John Bell. I'm the director of the Data Experiences and Visualization Studio at Dartmouth College. I am here in support of the position, but not representing a particular organization.
Great.
And I'm David Batman. I'm an associate professor in the School of Information at UC Berkeley, also here representing myself.
Wonderful. And then I do not believe I missed any of the proponents. And so if I did, go ahead and use that raise hand feature. Otherwise, let's go ahead and turn to those opposing the exemption. And why don't we start with AACS, LA?
Hi, good morning and good afternoon to everybody. My name is Michael Ayers. I'm legal counsel for the Advanced Access Content System Licensing Administrator. We usually refer to ourselves as AACS LA, and we're the developer and licensor of content protection technology for Blu-ray discs.
Wonderful. Then the Association of American Publishers.
Hi, I'm Jacqueline Charlesworth of Charlesworth Law, and I'm representing the Association of American Publishers today.
And then the proponent appearing on behalf of DVD CCA.
David Taylor, counsel to DVD CCA, and we are opposing.
Sorry.
That's okay.
Yeah. And then finally, appearing on behalf of the joint creators and copyright owners.
Yes, Robert Rothstein, Mitchell Silverberg and Nutt for the Motion Picture Association, the News Media Alliance, and the Recording Industry Association of America.
Wonderful. Thank you all very much. And to we're going to go ahead and start off with the questions for this class. And I believe I'm handing it over to Brittany Lamb.
Thank you, and good morning to everyone. I want to begin with a roadmap of where we're expecting to go in this discussion so that you have a sense of the topics that we're planning on covering. Hopefully, this will help you to limit your responses to the specific topics that we're discussing and help us move the discussion along. We'll begin with questions related to the proposed expansion, though some of our questions may also touch on the current exemption. Specifically, we are planning to cover the logistics of sharing corpora, such as record keeping, lawful acquisition of copies, and how to ensure compliance with the exemption. We are also planning to cover security concerns related to sharing corpora, the fair use analysis as it relates to sharing, and possible limitations on sharing. Our hope is that we will cover these topics within the first hour. Though the renewal for this class was not opposed, we plan on covering a few topics related to the existing exemption, such as collaboration, security measures, and viewing the copyrighted works. Time permitting, we will also plan on addressing some general issues pertaining to text and data mining. As you can see, we have a lot of material we would like to cover in a limited amount of time. We would appreciate it if you would be cognizant of time and giving your responses. With that, I'll turn it over to my colleague, Joanna.
Thanks, Brittany. So with our first question, under the proposed expansion, how would the corpora be shared? For example, would copies be distributed through a file transfer? Would access be given on a server by the host institution that created the corpora? Any information that you have on? Yes, Mr. Hansen.
Thank you. Yeah, so the proposed expansion focuses on essentially allowing for sharing as an extension of the existing exemption, which includes access for purposes of collaboration and replication. We think that it's pretty important that the specifics of how exactly that access happens be dictated by the technology that the researchers are actually using. One of the virtues, I think, of the existing exemption is that it allows for some flexibility in terms of the different types of technology and the different types of research environments that researchers are using. I think Emily Sherwood and David Baman, not to put you on the spot, but they may have some responses on this as well, about some of the technology that they use, and some of the different ways that universities have thought about access. But the essence of it is what we've seen and heard from researchers is kind of two sort of scenarios. One is one in which content is hosted on university servers, and outside users are kind of authenticated in and accessing them there. But it may also be necessary to actually share copies. And some of that has to do with technical challenges with remote access to high performance computing environments remotely. And for researchers to effectively use a corpus remotely, it would necessitate copies on their home campus. And I want to emphasize, I know this wasn't exactly the question, but I want to emphasize in those scenarios, researchers would be subject to all of the same limitations that they are under the existing reg, including all of the security requirements that apply currently. And I know we're going to get to that.
Okay, thank you. And I do have a follow-up on the topic. Would researchers be able to request only certain works from a corpus, or would the independent text and data mining need to occur on the corpus exactly as it exists in the originating institution?
I can at least answer that for our use case, for example. So the corpus.
Can you just introduce yourself as well?
Sorry. Yes, of
Thank
course.
you.
My name is Emily Sherwood. I'm here as representing University of Rochester Libraries. So in our instance, the corpus is created and generated in Mediate, which is the platform that hosts our data generation software. A researcher, for example, would create a research group and a project, and the videos would be uploaded to that space. If someone else, they are timestamped videos and the data is generated in timestamp nature. So having access to those videos as they exist in their timestamp nature is actually very important to ask or verify research questions on our data, because it is all timestamped and it needs to be within the framework that we have. The servers are secure and you would need to request access to the platform itself. And then the researcher you're collaborating with would actually have to invite you to that specific research group. That is the only way to access it. If, for example, you wanted to do research on, say, 5 of the films in our corpus instead of 70, then we could start a new research group that would still maintain the timestamp data of that specific corpus, but it would also allow you just to extract those 5. Say your library only had, owned 5 of those videos, you would then only have access to those 5.
Can I ask a follow-up question on that? On your response, which is, so in terms of like kind of one corpus, it sounds like there could be a number of subcorpuses that are created out of that corpus.
So yeah, so if you had a more limited research question that was looking at a smaller subset, it would be possible for us to extract those corpus into a separate research group. So you would only have access to, say, the 5, I'm making this up, the 5 films that you would like to look at and analyze, but they would still fall within the same timestamp data and be able to replicate and verify the data that we had already generated.
Okay, thank you. Mr. Band?
Yeah, I just wanted to clarify in response to that last question that, and this is my understanding, that it's not like a new corpus is being created. There is one corpus at, let's say, the University of Rochester Library that has the 70 works, and this is simply giving, this subgroup is simply giving access to a smaller group. It's not like it's creating a new corpus for those people. That's my understanding. Emily, please correct me if I'm wrong.
Yes, that's correct. We would be able to limit the access if requested to do so, but it would still be part of the same corpus. That's correct.
Okay, well yes, because that was actually just about, that was specifically my question. If there were multiple subcorpuses being created versus what it sounds like is more of, and by the way, I'm also gonna just thank you all to indulge us as we've tried to understand something that you work with much more frequently and have more familiarity with. But so if it is more a situation of with the existing corpus that a query is simply designed that would only pull from certain parts of the existing corpus. Is that correct?
Yes, it would be pulled from the existing corpus. So the corpus is there and it would be able to extract from the existing corpus the portion that you wanted to focus on. But it would still be the same corpus.
And if I could ask a quick follow-up question as well. So it sounds, and I'm sorry to pick on you so much, Ms. Sherwood, but it sounds like for what you are doing, it is hosted by your institution and it would be providing access to outside researchers rather than sharing it via file share or something like that. And so it would remain kind of hosted by University of Rochester Library. Is that correct?
That's correct. So we would maintain the corpus here at University of Rochester and grant permission to outside researchers as needed.
Okay. And is there a function to download the works if you're an outside researcher?
There is not, no.
Okay, thank you.
Mr. Bell?
Thanks. I think it is important to note that there are some use cases where actually copying the files to another institution would be necessary. And I can give an example for some of the projects that we are working on. We are doing large scale analysis using a lot of GPU resources that may not be available at an initial host organization, but we have available for us. Under that scenario, we would be copying files, but again, be doing so in the same sort of secure environment and under the same restrictions that we have in the existing exemption.
Okay, thank you. If we don't have any other responses on that, I think I'll turn it over at this time to Brittany.
Sure. Okay, so our next question, and this may be mostly for the proponents, but others should feel free to weigh in as well. We're interested in what forms of record keeping concerning corpora are currently in place and what degree of specificity the records used to identify the works in a corpus. For example, is it just by title or is a unique identifier like an ISBN used to identify a specific edition of a work? Mr. Bannon?
So thank you for that question. So for our work here too, we've digitized about 2,500 DVDs, and I would love to tell you all about the kind of projects that we've done with this data if you wanted to ask a question about that. But for the specific question, we do keep detailed records about the specific version of the DVD that we've digitized. So that includes not just the title, but the UPC number. And part of that is to be able to enable reproducibility by others, right? So if some other researcher wanted to replicate exactly my same research question, they need to know exactly what the materials were that we ran our analysis on so they could purchase the same DVDs and run them themselves. One of the issues I want to raise for this particular exemption is that it's not always possible for different researchers to purchase exactly the same DVD that I have. Right, so it may be the case that I've bought the last remaining copy of a movie that was published in 1981 or something that's really difficult to find. And when you purchase these DVDs from sources like Amazon and thrift books like I have, you don't always know exactly which particular item of that work that you're buying. So part of what I'm envisioning here for this particular exemption is that being able to purchase a specific title would allow sharing of these individual different UPC numbers for the different DVDs. But yes, for record keeping, we log all of those specific items that we purchase.
Okay, thank you. I think you actually anticipated my follow-up question, which is whether you would need to purchase the exact same edition of the work or if having some other version or edition would be sufficient. So if anyone else wants to weigh in and discuss both issues, yeah, that'd be great. But Mr. Bannon, we can get back to you.
I'm happy to defer to others if you want to jump in ahead of me. But what I will say is that, yeah, so for our case, it's often really important to be able to have the exact copy that we ran our analysis on for others to be able to verify our results independently. So if they were to go out and buy the same title, but a different version, so say we buy the widescreen version, they buy the director's cut, it means that the films are not going to be exactly the same, right? They may have different run times, they may have different aspect ratios, there may be some subtle differences between those two. So that if I'm sharing metadata, right, about the films that we've generated through our algorithmic processes, like who the actors are in each individual frame, they wouldn't necessarily be comparable across those two different items. So being able to share the exact copy of the data that we've run our analysis on, I think is going to be important, simply for scientific reproducibility's sake.
Mr. Bell.
I would just add to that, it's not even just limited to the different versions of a film that might appear on different disks. It's also down to things like the technical encoding of the files. In some cases, that actually makes a difference to the analysis. So having the actual exact copies of the files for verification purposes and trying to figure out if there are additional related questions that would then be comparable to the original work, that's an important aspect of it as well.
So unless anyone else has anything they would like to say on that, my next question is it sufficient for the recipient institution to have a copy of the works at the corpus in their libraries, or does the researcher need to separately acquire the copies? Mr. Hanson.
Yeah, so our position is that, this is an extension of the existing exemption. The existing exemption says that it's the institution that has to own the copy, not the individual researcher. Where that institution houses the copy, whether it's in a media center, in a lab, in a university library, the current exemption doesn't specify. And I can say, talking with lots of people in this community, that current practice under the existing exemption is that it's all of the above. People have followed a variety of those approaches. And so for this, I think, holding the copy in the library certainly would be sufficient, but not necessary. It could be held in some other sub-organizational unit of the university.
And if I could, jump in on a follow-up on that, as well as if there's anyone else on behalf of proponents who have more to say on that answer, we'd like to hear it. It is helpful to understand how the current exemption has been interpreted. But in the cases you were discussing, where perhaps another part of the institution holds the copy, how does the researcher or those who are responsible for the corpus ensure that a copy is actually, that the copy is actually maintained? And how does that relate to record keeping? Because I do think that there are questions about how has this worked over the last 3 weeks, 3 years, and then what the, proposed expansion would specifically mean in terms of logistics.
Mr. Bell.
I can say how it worked for us. We've had our library and film and media studies department go through their collections and pull specific discs out at our request. We already have a list of those, obviously, and we just went through and selected them for use in this study. We do definitely keep all of these records anyways, because it's part of the publication process and the research process to understand what is actually in the corpus itself. So having all of those on hand is important to the scholarly work, not just the record keeping portion of it here. Beyond that, I think the sort of ongoing question of whether or not the disk is maintained in the library. Long story short, that's something that we deal with a fair amount. And so there are existing processes in place to say that, look, we are using this, it is actively being processed and worked on. And so therefore, please make it available for us over a longer period of time.
And Mr. Bamman?
Yeah, just to give you a sense about the variety of practices here. So the only DVDs that we digitize are ones that I've bought for this specific research purpose. I would have, which may mean that there are multiple copies that the institution owns, because the library also may own the same copy in a different format. I would have no problem going to the library and asking to digitize those versions. But just to be able to maintain more direct research control over our specific corpus, I bought them all and digitized them, and keep records about all of those ones that we've digitized.
Thank you. And Ms. Sherwood?
Yes, similarly to Dr. Bell, at University of Rochester, we purchased them through the library collections. So all of the videos used for this particular research project were purchased through library collection funds and also partially funded by the Film and Media Studies Department, but they all exist in our library collection.
Okay, thank you. I think I'm going to turn it over to Mr. Goldberg to see if he has any questions.
Great, thank you. This discussion has made me wonder a bit about the peer review process prior to publication. To what extent have proponents found that they need the ability to share a corpus for peer review purposes instead of just with researchers at other institutions? Or, you know, is that something that's needed? Is that something that can be excluded here? I'm just sort of curious about how that works.
Mr. Bell?
Sure. The short version is that we haven't been doing that very much because it hasn't been part of the existing rule. I think that this is an opportunity to really think a little bit about what quantitative digital humanities means as a discipline, because we're starting to get more into the types of methodologies that have traditionally been used more in STEM research and in the sciences and NSF grants and things like that, where that kind of peer review ahead of time is much more common. The history in the humanities has been more qualitative in nature. Peer review has a different feel to it, so I don't think that we've had the need to do that quite as much in the past. And that's one of the things I'm hoping for with this new extension, is to be able to enable some of those methodologies and bring some of those quantitative modes of operation over into the humanities.
Thank you. And Mr. Bamman?
Yeah, and I will say for us too, we have a project right now that's measuring representation for race and gender in movies, or Hollywood movies, over the past 40 years. And this particular topic is one that I'm deeply concerned about when it comes to publication, because we're at the stage now of writing up all of our results to submit to a major journal. And reproducibility is a big part of the review process, right? That one strategy that people often use is to provide access to derived metadata. So in our context, we have information about who the actor is in every frame of a movie. We could give that to reviewers to let them verify that derivative phase. But starting from the movie itself to get those derived metadata would not be possible with this particular collection. And so we haven't run up against those kind of hurdles yet, but I'm expecting that we're going to, and it is a concern.
Okay, thank you. And Mr. Hansen?
Thank you. So I wanted to comment because, as I think I've mentioned, we've been talking with lots of text data mining researchers and lots of different research environments. And so just as sort of an aggregate, data point across them. I think there are some different approaches to the current exemption. The current exemption does allow for sharing access for verification purposes. And so we have heard of some folks looking at that and saying, gee, that would actually facilitate some level of access for kind of peer review process. And I think that's what you get with, you know, a new regulation. This is a 3-year-old regulation, and it's kind of a learning experience. So people are reading it in different ways and using it in different ways. But I just thought you should have that data point. And I wanted to make sure we kind of got out there that, you know, there are certain levels of access that are already permitted for kind of outsiders in the current exemption, including for verification purposes.
So can I just ask a follow-up for clarification? Is peer review something that you as researchers would consider part of verification? Let's start with Mr. Bell.
Again, I think that it depends on the discipline. I think that that is the direction that we are going, but because we come from a more sort of qualitative background and are going in a quantitative direction, that is still an emerging practice in at least my discipline.
Mr. Gammon.
And I would say yes, too, that peer review is part of the definition of what verification is. In my context, I tend to be very conservative with our security risk. And so if one of the options for allowing others to verify the results of our research is to give them access to our secure environment, I'm less open to that for people who I don't know and don't have strong collaborative ties with. So peer review would fall into this particular category, I think.
Okay, thank you. It looks like we don't have any more hands on this topic, so I'm going to move on to the next question here. And this one might also be best suited for the proponents, but anyone should feel free to answer. If a corpus is shared either under the proposed expansion or as part of collaboration under the current exemption, what happens if a work in that corpus is no longer available to be lawfully acquired? Is it removed from the corpus before it's shared? Is that even possible? Yes, Mr. Hanson.
Thank you. So I just want to make sure I understand the question or the scenario. So the situation is, you know, University A creates a corpus based on, let's say, a set of 100 DVDs, shares that with University B because they already own those same DVDs. They've lawfully acquired them at some point. And then at some point in time, that DVD gets taken off the market or is no longer available for sale?
I think we're envisioning a scenario where this happens before the collaboration or the corpus is being shared. If there's a subset of the corpus that somebody wants to study and they request access, but they learned that Title X is no longer available, but it was in the original corpus that they are seeking to study, what would happen at that point?
Ah, I see. Well, I'd invite some of the text data mining researchers on the call to chime in on the technicalities of actually removing things from the corpus. But in terms of what we are proposing, access would only be allowable for titles that the receiving institution actually owns a copy of. And so if they can't get a copy of it in some lawful manner for whatever reason, then that title would need to be excluded from the corpus. And I think Emily Sherwood has talked a little bit about the possibility of sort of subsetting aspects of an existing corpus. So maybe she could chime in. That's I think the scenario that would happen is that receiving institution would have to somehow not receive that title that they don't own.
Yeah, I think as I explained before, what we could do is remove access to those individualized videos from the people who are requesting access via our platform.
Okay, thank you. And Mr. Band?
Yeah, and I just want, this is sort of like a higher level comment. I just hope that you all understand how at some level that constraint that we're agreeing to is absurd. I mean, it just kind of goes against the fiber of research and fair use and the way libraries work. But, in the interests of making this process work, we're willing to agree to that kind of restriction. I mean, it frankly makes no sense, especially given the reality that one could go online and find, that an infringing copy of that work, in hundreds of places. But, in the interests of this process, we're, willing to, tie our hands, behind our back.
Okay, thank you for that comment. I think I have a somewhat related comment. Who is responsible for ensuring that the works are lawfully acquired? Is that on the originating institution or on the receiving institution? Mr. Hanson?
I think this is a pretty straightforward issue of like the institution that is circumventing TPMs in the first instance would have the responsibility of ensuring that they acquired access or acquired the copies lawfully. And just as a side comment on that, I think that largely happens through university libraries and other through research teams that are pretty careful about where they are getting things from. And so in that instance, they're responsible as they create the corpus, and then for the institution on the receiving end, they would have to do the matching up to make sure that they actually own the titles that they are requesting access to, and that would happen upon acquisition there. I guess I would also just interject in this that acquisition workflows for different institutions can vary, but especially at larger institutions where a lot of this happens at an institutional level that goes through procurement offices, that goes through a kind of bureaucratic process. There's a lot of steps along the way to prevent unlawfully made copies from being acquired.
Okay, thank you. I think with that, I'm going to turn it over. Sorry, Susie, did you have something?
I just have one, also, David Jonathan Taylor, you have your hand up, and so I want to give you a chance to speak, and let me just kind of throw in a follow-up question, which is simply under the proposed expansion, if again, as was described, the original creator of the corpus will have lawfully acquired the works, and they're the ones who are circumventing the TPMs. And then if the corpus is shared, how does the obligation, we know that the obligation is on the sharing, the institution that's receiving the corpus and obtaining access, but is there any record keeping obligation on the original institution with regard to, these requirements were disclosed, we have a certification that this has occurred, anything else like that?
And we'll start with Mr. Taylor.
Well, actually, let's start with the proponents first, because that's a proponent question, and then we'll go to, I know the opponents have lined up with their hands.
Okay.
Mr. Hanson, did you want to answer that?
Sure, I'm happy to. And I think as some of the researchers have already mentioned, record keeping is pretty important as part of the research process for publication, for peer review. And so in our proposed text, we haven't indicated any sort of record keeping requirement in there. it would be highly unusual for an institution not to keep records of what they are using, because researchers need that as part of their research process. But I don't think it would be unreasonable for an institution to, have to keep a record of like, what do they own, when do they own it, when did this happen, those kinds of things. I guess the only little concern I have with that is, the proposed text that we suggested as an expansion on this regulation is relatively straightforward. The regulation is already rather long. It's frankly kind of intimidating to a lot of researchers. And so I would say if there is a record keeping requirement, it would be helpful to make it straightforward so that people can really understand it and use it. And I say that in the context of over the last 2 years, I've done workshops at probably 24 universities, meeting with over 1,000 different researchers to try to help them understand how to use this, because they're not lawyers, they're not copyright experts, and so they're trying to navigate a kind of complex process. So I guess that's sort of a generalized regulatory suggestion, is that there's a real virtue in simplicity to help ensure actual real compliance.
Thank you.
Okay, and I think since Mr. Taylor, you had your hand up from before, we'll start with you.
All right. Yes, I just wanted to respond to Mr. Hansen's suggestion that the burden would fall on the receiving institution, that they would have to verify it. I mean, the active circumvention is being done by the initial creating the corpus, and if it is subject to the limitation that it can share, provided that the other institution would have those same copies of works, then in order for it to circumvent lawfully, the burden must fall on the institution that builds the initial corpus.
Okay, thank you, Mr. Rothstein.
Sure. I just want to point out that stepping back, we've been talking about two things. This doesn't involve only access. It involves copying and distribution. And it's not even limited distribution. We haven't talked about the fact that the receiving institution can redistribute to another institution, presumably under the proposed extension. And also, I'm hearing conflicting concur. The first comment by the proponent was that if a certain title is unavailable or even different, that doesn't work for the research. So presumably, for the research to work, one would have to, send the full corpus with the version of, say, a DVD that wasn't purchasable, and that's problematic. And just thirdly, really quickly, I have to respond to Mr. Band's comment that limitations are absurd. I frankly think that unlimited distribution of corpus doesn't have any basis in the law.
Okay, thank you. And I think we do have some questions on that later on here. So for right now, Ms. Charlesworth.
Yes, thank you. This is more of I apologize, a comment than a question, but we've heard a lot about the maintenance of motion pictures, but we haven't heard anything about books and how those are tracked, and what kind of record keeping pertains to books. I imagine some of those corpora could be much larger, and I was just curious from since I represent book publishers, whether there was anyone who could speak to the specifics of books and journal articles and other things that are being circumvented under the rule.
Okay, I think let's get Mr. Ayers had a response, and then if anyone can add to that.
Thank you. Thank you. So to piggyback on a comment that David Taylor had made, I think it would be important to clarify that it's not only the originating institution that should have the obligation. It's both institutions, both the originating and the receiving institution. The originating institution is the one doing the original circumvention, and its obligation under the proposed expansion would be to only share their corpus with another institution that is also following the rules. And so there needs to at least be, it's not just a mere matter of record keeping of what was handed over, but making sure there was an appropriate basis for the handover in the first place, including at the very least some representation that by the receiving institution that they had legally obtained copies of the works that they're accessing. And I would just note more broadly, related to a couple of the earlier comments in this session, that we certainly hear a lot of folks who are trying to do some very good work, but we're also aware of in the submissions that had preceded this hearing, we've got examples of institutions which are already interpreting the current exemption in ways that are inconsistent with the current exemption. And so to the extent those, not only with the current exemption, but even with the proposed expansion, including soliciting copies from other institutions to make collections of clips, performing close viewing of works, which is something that in the earlier proceeding 3 years ago, we'd been assured that viewing of the works was not necessary unless it was for verification purposes. And we're seeing now that it's actually considered very necessary to some of the work being proposed. So I think we need to be aware at a very high level that the expansion that is proposed is perhaps not actually the expansion that is going to be practically implemented. And so we should make sure that our work there is very thoughtful and careful in considering not only what the text of the proposed expansion would include, but also what practical impact is that likely to have on entities that are already acting outside the current existing exemption.
I'm going to have to cut you off here just in the interest of time. We do have a lot to get to. Very briefly, Mr. Banman, we'll let you respond. And then Mr. Rothstein, if your hand is still up from the last time, if you could put it down, thank you. So Mr. Banman, and then we're going to move on.
Great, thank you. Yeah, so just to respond to two of the comments there. So on the points about the different DVD versions being different, what I meant there was that if I purchased and digitized a version of The Empire Strikes Back from 1980, and that version is no longer in print, but a different institution could buy a different version of The Empire Strikes Back, then I'm wondering if that is a basis for me to be able to transfer or to give access to my particular copy, since it's the copyrighted work, if not the specific version that we have. Now, on the point about books, right, we've all been discussing movies exclusively here. And from my experience, we have not used this exemption with ebooks at all. Right now, in part because this is due to contractual override issues that the books that we would love to be able to work with, we would have to purchase from Amazon or other places whose terms of service prohibit breaking DRM to do this kind of work. So we're still trying to find a way of making this exemption useful for doing anything with books at all.
Okay, thank you. And at this time, Mr. Goldberg, you have a question?
Great, thank you. Very quickly, Mr. Ayers made an interesting point around the requirements falling on multiple institutions, which, raise an interesting idea for me, which is how should we think about the possibility that an act of circumvention, which perhaps for argument's sake, let's say, is compliant with the terms of an exemption at the time it happens, later falling outside of the exemption because of something that, perhaps another institution did improperly, maybe years later. I'm curious to hear about both sides of, sort of about the extent to which an act of circumvention could retroactively fall outside the scope of an exemption.
Ms. Howard-Sukol?
So I just want to clarify, I actually have a point in response to Ms. Charlesworth's question about books. And so I'm happy to clarify that, or if someone else wants to answer Mr. Goldberg's question first, that's fine with me.
We don't have any other hands at this time, so.
Okay. Okay, so I just want to say that my own background, I can speak to this a little bit, and I am a clinical law student representing, Authors Alliance. But prior to attending law school, I received my PhD in English literature from the University of Virginia with specializations in contemporary literature and the digital humanities. After this, I served as a digital humanities postdoctoral fellow at Bucknell University, and I do have direct experience working on TDM works and developing TDM corpora. I will say very briefly that I left the Academy before the 2021 exemption was passed, but I just do want to clarify that having worked on corpora that were at the time, in the public domain, record keeping is an essential part of any scholar who is working, whether they're working on DVDs or text-based materials. So to Ms. Charlesworth's point, that would be something that is maintained. So thank you.
Thank you. And Mr. Band?
Yeah, I guess to respond to Mr. Goldberg's question, the question with respect to every fact situation is going to be slightly different, and one would have to do the legal analysis with respect to that that issue. So certainly the way the Copyright Office is interpreting the exemptions is that, even if you circumvented a work lawfully at a certain time, then what you're able to do with that could change at different periods of time. I'm not sure that's necessarily, my personal view is that might necessarily be right, meaning if the circumvention is legal when you do it, and then, I would think that what you then do with it is beyond the scope of Section 1201, but certainly the Copyright Office has not been interpreting that, and no one has been acting as if, you only look at it, the issue of circumvention and the lawfulness of the circumvention at the time it was done, and then Section 1201 becomes completely irrelevant because at that point the work is, as it were, in the clear. So that would mean that if you, even if it is part of the corpus of Institution 1, then if Institution 2 at a later date is trying to access it, then one would look at, is it lawful at that point for there to be a distribution to Institution 2.
Thank you. Mr. Taylor?
Yes, I guess I would have to disagree with Mr. Ben that you can't look down the chain because the exemption only exists and permits the circumvention in the case of sharing is, if there is downstream liability. So as a condition to circumvent in the first place, you have to have downstream liability.
Okay, thank you. Mr. Hanson?
So I think this in a way addresses the downstream liability question, and also a comment that Mr. Ayers made previously about who is responsible for ensuring compliance. And I agree, actually. I think that both institutions have an obligation, both the receiving and the sending. The way that we have suggested the text is that it says the sharing is allowed where those researchers are in compliance with the exemption. And so that receiving institution would have to do all of the checks. It would have to ensure all of the security requirements are in place. It would have to ensure that they owned those copies. And that sort of liability flows because the institution that does the circumvention would have some obligation to ensure that the receiving institution actually is in compliance. So we're not trying to like get receiving institutions out of some sort of liability so they can do whatever they want with these copies. I think the idea here is to say the very same obligations that are imposed on the institution that does the work of circumventing TPMs, because it is so time intensive and technical. The downstream institution has to comply by all of the exact same rules. And we want to put them on a level playing field. That's the intent.
Okay, thank you. I think at this point, Brittany, I'm going to hand it over to you.
Okay, thank you. So our next question is, if the proposed expansion is granted, can the researchers or institutions request monetary compensation or some other kind of benefit in exchange for sharing a corpus?
I'll just jump in since we don't have any hands up. Oh, we got a couple up. All right, because I think we felt that this was not addressed in the proposal. We wanted to make sure we understood what the intent was and what the thoughts were on this issue. So Brittany, I'll hand it back to you to call on those with their hands up.
Sure. So we'll start with Ms. Charlesworth.
Well, I maybe I should go last and respond to what Mr. Bell and Mr. Hansen may have to say on this before I jump in.
Sure. Yes, we can start with Mr. Bell then.
I would just say that that wouldn't be that charging would not be consistent with the practices that we have in other types of data sharing situations for research. So I wouldn't think that we would try to do something like that here either.
Thank you. And Mr. Hansen?
John sort of answered it. Same answer. I just point out, the exemption is limited to uses at nonprofit institutions of higher education. That isn't to say, nonprofits don't exchange a lot of money, but this is not for any sort of commercial purpose.
Okay, thank you. And Mr. Taylor?
Yes, I would just simply say that it becomes problematic to the extent that you're creating a service that is a corpus lending service. And even if it's not quote unquote for profits, even if it's for cost sharing, I think it becomes more of a corpus lending service.
Sure, Mr. Sherwin.
Sorry. We would not charge at all for cost sharing, and it wouldn't become a corpus lending service because the other institution would also be required to purchase the DVDs or the videos at play. So there would be no financial benefit.
Okay, thank you. And Ms. Charlesworth.
No, thank you. I mean, I think the reason I jumped up with my hand there was because I think this could lead to a lot of problems where money is changing hands. And it certainly seems inconsistent to me with the spirit. I think this was mentioned earlier of this being solely for academic nonprofit purposes. And in fact, I think, the current version of the rule could be buttoned down even a little bit more. And this is briefly mentioned in our papers, but, to the extent there's a renewal of the exemption, it really should be limited strictly to academic nonprofit purposes. And the corpora shouldn't be shared, shouldn't be sent off to commercial users or in any way monetized. That's AAP's view. And I think that I'm hoping the Copyright Office will make that clear.
Okay, thank you. I will hand it back to Joanna.
Thank you. So if the proposed expansion is granted, who should be responsible for ensuring that recipient institutions and researchers use effective security measures? Mr. Ayers?
Thank you. I would go back to our earlier comment about ensuring that the movies in question or the works in question are actually owned. And I think there would have to be a responsibility on both sides. Because again, the idea is that the sharing should not take place unless it's with an entity that is also operating under the same exemption conditions. And so that has to be ascertained. And again, I think we can also look to current uses that are purportedly under the current exemption that are inconsistent with that. So again, I think we would need to make sure that any security obligation would have to be shared and perhaps more clearly set out than is current.
Okay, thank you. And Mr. Hanson?
I think the answer is both the sending and the receiving institution are responsible for ensuring their security requirements. I think this is also a good moment to point out that institutions actually do this all the time with all sorts of data, particularly when you look at research happening in clinical health fields or other areas where data security is particularly important. Universities are actually really good at this, and they do this with regularity with agreements amongst them about how to ensure security compliance. And so I think that, again, both institutions would need to comply.
Okay, thank you. Brittany, I'll hand it over to you.
Sure. So my next question is, if the proposed expansion is granted, should additional security measures be imposed to safeguard a corpus while it is being shared? So this would be not a situation where the originated institution just grants access, but if there's a file share kind of situation, should security measures be in place to govern kind of the transitory period? Mr. Cha.
Yeah, institutions already have these standards in place for the safe and secure transmission of sensitive data. Like Dave said, this isn't really anything new. For example, Berkeley's minimum security standards for electronic information expressly require the use of secure, authenticated, and industry accepted encryption mechanisms when transferring sensitive data. For data at rest, the standards include the use of industry standard encryption, intrusion detection systems, and network security policies such as audit logging, access controls, and appropriate physical and environmental security controls. Other institutions similarly have methods to protect their own highly confidential information. And yeah, the receiving institutions have to follow these same security requirements of the exemptions, and they currently have the capacity to securely transmit data and the standards to do so.
Thank you. Mr. Ayers?
Right, thank you. I would point out that security was discussed in the last go round on this issue, and certainly is a concern here too when sharing that while certainly there are entities that will act very responsibly and take very seriously the secure treatment of that data, where it's important to make sure that there are appropriate standards so that every entity who is engaging in this exemption follows those standards. And I would note that more specifically to the question you asked as to whether there needs to be particular security standards in place for the transfer of the files from one entity to the other, I would say yes, absolutely. The whole reason that these works were protected in the first place was to prevent their unlawful and unauthorized sharing, including basically a soup to nuts, beginning to end encryption and protection system that protects the work from the moment it's created with the motion picture studio and the replicator, all the way through until it is viewed in according to analog eyeballs. And so to take it out of that environment and then not apply appropriate security at some point in the authorized exemption use is problematic indeed.
Thank you. Mr. Taylor?
Yes, thank you. I just want to say I hear a lot of trust us. Universities know how to do this, but what we've seen in practice is that there seems to be a large disconnect between the researchers and the work they're doing and what universities actually know the researchers are doing. For example, it was very easy for me to get access to a database, and demonstrated to me that there was no security in place. Reviewing the comments of the MPA and the reply comments, I got the very strong sense that counsel for the universities were not aware of what the researchers were in fact doing, and were very reluctant to come forward and defend those actions, and couldn't provide the assurances that the university really is protecting this content as the regulation would require.
Okay, thank you. Ms. Charlesworth?
Yes, thank you. Well, I want to echo that and say, it's one thing to have a rule in place and a policy in place, but it's quite another to connect it to and actually implement it with respect to projects like this. And I don't want to rehearse everything that was already in our papers, but we sent out letters. There was a lot of resistance to responding. We didn't get any real substantive response on the question of what exactly are you doing to, in working with researchers who are doing this work to ensure that the security measures applicable to highly confidential information at your institution are actually being applied here, which would include probably some amount of training, so, where are the corpora being hosted? This gets to the broader theme of transparency. There's just simply no transparency on what's going on here. And as copyright owners, we're sitting here in the dark and not understanding whether anything is actually being observed under the rule. I mean, so it's, we keep, as I think was just said, we keep hearing, well, trust us, the rule says this, the rule will ensure this, but that's really quite a difference between sort of thought and action. So I think, and this may be for a later discussion in the hearing, but we really need mechanisms where the copyright owners can reliably check. They need to know what works are being used. Apparently the records are being kept. So that's one point that we've covered a fair amount. And number two, we need to be able to understand exactly how the procedures are being applied, the security procedures in particular, in addition to, the lawful copy procedure, how they're being applied. And there just needs to be some ability in a situation like this where you have massive corpora of DRM-free work. Really, the fair use question ultimately depends on appropriate security, as in Hathi Trust and Google Books, and there needs to be much more ability to confirm that.
Okay, yeah, thank you. Just to remind everyone, we are very short on time. So we will discuss security measures later on as well, but if everyone can kind of focus on the specific issue and keep responses brief, that would be fantastic. So briefly, I'll turn to Mr. Hansen then.
Well, I was going to respond. I mean, on the issue of security of the corpus at which institution, and whether universities have the capacity to do this, I point out, as far as I'm aware, there's no evidence of any TDM researchers corpus being breached, any security incidents out there reported on that. This is not research that's happening kind of in secret. Researchers are publishing their work. It's out there in peer-reviewed outlets. All of this stuff is available, and as far as I'm aware, there's no evidence of breaches. And regarding, investigation into security practices, I guess I just point out with regard to these letters, there actually were substantive responses on those. They were put in place, or they were sent with a very short timeline for individuals to respond to very large institutions with a wide variety of research activity. And frankly, they were sent with kind of questions about their validity. For example, the AAP letter, sending letters to the University of California and Stanford University on behalf of presses that are housed within those own institutions, which AAP referred to as requesting presses. And based on conversations I've had with press directors, they were never consulted or asked, at least in some instances, about whether those requests should go out on their behalf.
Okay, thank you. I'm so sorry, but we have to move on to our next question. So I'm going to hand it back over to Joanna.
Thank you, Brittany. So should a copyright owner be entitled to inquire into whether and where a corpus has been shared? Ms. Charlesworth?
I will be brief, of course. Of course, you know, in the interest of transparency, copyright owners should know where their works are being shared.
Okay, thank you. Mr. Taylor?
Yes, and I absolutely agree with Ms. Charlesworth that it's not only the copyright owner, but it's also the representatives and be them trade associations or the like. I mean, to suggest that the trade association who are here making these representations can't turn around and ask how are these representations actually enforced. I mean, that seems a little disingenuous. And we've come across this issue about the role of certain collection societies. I don't see any difference of why the Copyright Office can't make it perfectly clear that the trade associations that represent different parties in this proceeding also should have the authority, clear authority, to be able to ask these questions of how the rule is being implemented.
Thank you. Mr. Band?
So just to be ornery, that was a joke. No, I would say as a general matter, no, for the simple reason that if you look at across all of the other exemptions under 1201, there is not the ability to start engaging in, frankly, fishing expeditions, as was done in this instance, in a manner and timing that was clearly intended to intimidate researchers. You know, we've been talking about, I mean, some of the opponents have been talking about the massive size of these corpora, but you know, we don't know actually, you know, there's no evidence that they are really that massive. We've heard of relatively small numbers actually so far, but even if they are massive, I mean, and other exemptions also involve large numbers of works. I mean, the real sort of the proof is in the pudding that there are, you know, with all of these exemptions, across all of the years of section 1201. I mean, I don't know if there's any evidence of any leakage whatsoever. And that goes back to my earlier point. Why would anyone bother sort of cheating on 1201 when you can just find everything out on the open web? You know, there's a complete disconnect. But the bottom line is that no, there should not be an invitation for fishing expeditions.
All right, so I'm just going to jump in here. We are aware in the record of the discussion and different opinions regarding letters that were sent and the responses that were received. But to respond to, you know, some of Mr. Band's comments, in the existing exemption, it provided an opportunity for a copyright owner to inquire. And one question that has come up is, and maybe particularly against the backdrop of the dueling letters, is how does a copyright owner know to inquire if that is something that was provided to them in connection with the first exemption? So that's kind of a question of, you know, is in the current exemption, does that work? And I think with respect to everyone who might be ready to respond to say no, we get a little bit of the no from what occurred prior to in connection with this rulemaking. But then the question is that something that should continue? If so, how do we make that workable? And I'm going to assume that some of those who have their hands up might have an answer to that. And I will ask Mr. Rothstein to go ahead.
It should continue and it should be expanded. There should be some notice provision. I don't want to belabor the letters, but I'll give one example. You know, at least one of the responses said, we're not going to respond because only the copyright owners can take advantage of this. And we don't know that you're a copyright owner. So how does one know? to make this work, it's really essential that there be some sort of record keeping notice to the copyright owners, and be more efficient actually to do that, because the copyright owners would presumably know whom to ask.
Okay, thank you.
Thank you. I say, Mr. Ayers. Thanks, Joanna.
Yeah, just to sort of disagree with Mr. Band, I would say that even if the current corpora are not quote unquote massive, I think in the discussions in the last go round and here again, we're anticipating that they certainly could be. That was certainly one of the reasons for the concerns about how securely these corpora were maintained. But also because we're talking about now not just siloed corpora in individual institutions, but sharing these corpora in a network of institutions in one form or another, whether it's simply access to look at the data or actually engaging in the file transfer that's been discussed a little bit. And so we do end up having something that even if it starts out small in one location could end up being massive, and that becomes a big target for those who, even though certainly individual movies can be downloaded from various sources online for those who are interested, this treasure trove of content is a pretty attractive target once the appropriate parties start becoming aware of it.
Thank you. Ms. Charlesworth?
Yeah, no, I just wanted to say, I mean, I think Mr. Band's comments that this was some sort of a fishing expedition are really not appropriate. The burden here is on the proponents to show that they're entitled to do this, and the basis of their argument is fair use. And the fair use argument, as we discussed in the last proceeding and again in this proceeding, is based on effective security measures. So it really, apart from responding to the letters in an appropriate or failing to respond in an appropriate way, I mean, there was an option here, given the reply period, to actually make the case that the security measures were actually being properly implemented, that researchers knew about them, that the institutions knew what was going on, and that was not done. And that's very concerning to copyright owners for all the reasons that have been expressed. I mean, you have a potentially massive corpora of copyrighted works, and they are, could clearly be targets. And this was really important in the Google Books and HathiTrust cases. So it's not, it was number one, an appropriate request. Number two, of course, a trade association that's been authorized by its members to make the request should be able to make the request. And again, I just want to emphasize or reiterate the point that, yes, it would be really helpful to know who's actually using what, so that we would know who to ask. And that, I think was a little bit of an oversight in the last rule.
Thank you for that comment. We're going to hear from Mr. Hansen and then Mr. Bell, and then we're going to go ahead and move on to our next question. Mr. Hansen?
Yeah, so I guess I'll try to keep this brief because I know we're short on time. I think the current exemption is reasonable. It allows for copyright owners to make inquiries. And I think you really have to be a copyright owner to do this. And they have to be reasonable requests, which is what the regulation says. I also want to emphasize that none of this research is happening in a corner. Researchers are publishing their research. They're including their methodology. All of this is out in the open. And at that point, that's one place where copyright owners can learn about what's going on, see this kind of activity happening. If they have a concern about, a particular work that they think maybe is pirated or somehow is out on the web, they can do their investigation and see very clearly what kind of work has been done by TDM researchers using corpora. In terms of notification, I think it's perfectly reasonable for institutions to keep records, and I think in order to comply adequately with the existing reg and with our proposed expansion, they would need to keep really good records of what they're doing and what they have. But notification, I think, is actually a real challenge and would be practically unworkable. Who to notify, how to notify. The Copyright Office is well aware that who exactly the rights holder is of any particular work is not always a very clear question to answer. And so, researchers are doing this in a way that is very much out in the open and very much available for copyright owners to investigate at that stage.
And just one quick follow-up, just to make sure I understand your comment. But when you state that it is out in the open and people know what's happening, is that only at the point of publication of a research, or is there an earlier? I just want to make sure that I'm not missing a detail that you might be providing in terms of an earlier public access or information opportunity for a copyright owner.
I'll let Mr. Bell respond maybe a
Okay.
little on that.
Great, thank you, Mr. Bell.
Sure. So most of the time, I think that the publication would be the moment when all of the data sort of goes out. And by data here, I mean the records of what is in the particular corpus. But to go back to the point about notification, I'll just say that from practical purposes from somebody who's doing this kind of work, notification is not realistic. And I say that because of the issues of identifying, yes, but also the time involved in going back and forth and trying to figure that out. I can tell you that on the existing projects or project I'm using the TDM exemption for, 15% of the budget is spent on just the circumvention. And if we were to then extend that to going into the legal process of notifying everybody, identifying who everybody is across a large corpus of materials, that is going to shut down a lot of possibilities and basically make it impossible to even realistically apply for a grant in a lot of cases, much less receive one and execute it.
Okay, thank you. And I know there are two hands raised, but I think at this point, we're so far behind that we're going to need to move on to the next question. Brittany, I'm going to hand it over to you.
Sure. Thanks, everyone. So if the current exemption is expanded in line with the proponent's request, should there be any limits on sharing corpora? For example, should there be limits on the number of institutions or researchers the corpus can be shared with? Or should only the institution or researcher that created the corpus be permitted to share it? And should recipient institutions or researchers be prohibited from further distribution of that corpus? Mr. Bell?
I'll say that just whether something should or shouldn't happen, the practicality of it is that you're going to generally have to go back to the originating organization anyways, because you're not going to have copies of things that you are not actively using hanging around your servers once you've received them from another institution. That just adds more overhead, it adds more maintenance, and we don't want to try to create an abstract set of materials. We only want to work with materials that are actually relevant to the thing that's in front of us.
Okay, if there's no one, oh, Mr. Witcher.
As we have stated previously, in our situation, it would always come back to the original corpus owner because we would be granting access to our corpus versus sharing a corpus and then having others share that moving on.
Okay, thank you. So if there isn't anyone else, I'll hand it back over to Joanna. Oh, sorry, Mr. Rothstein.
Just briefly, I think it goes without saying that we think there should be no expansion, but I still didn't hear, just saying, well, our policy is that we won't, doesn't mean that it won't happen. And that a resharing won't happen. And that remains a concern that, certainly there's an incentive to do that based on what the proponents are saying, because the issues of cost. So just pointing out that there was no answer that it won't happen.
I have a quick follow-up question, which has to do with, again, kind of the sharing, the proposal to share. when a corpus is shared, and this applies both in the situations of institutions that may simply grant access, though I think the answer is going to be easier, and then those that actually share the actual, data in the corpus to be resident on another institution's servers. When that research is completed by the receiving institution, is it the proponent's anticipation that access would cease, or that the copy that was shared would be deleted? Mr. Hanson.
I think that this would be driven on a case-by-case basis, but I think there are strong reasons to think that in some circumstances, it would be really important for the receiving institution to hold on to that data in a secure environment for downstream reproducibility. There's a strong interest for scientific research to have a pathway for subsequent researchers to verify whether a given study was actually accurately done. And I'm sure you've seen some of these things in the news of sort of scandals with people modifying their data and then no one ever being able to follow up on it. And so there are strong reasons why, from a research integrity standpoint, it would be important for some institutions in some circumstances to keep a copy.
Mr. Ayers?
As Mr. Rothstein mentioned a little bit ago, again, we would oppose any expansion, but to the extent an expansion is being considered, the limitations on the sharing would need to be, at the very least, assurances, representations by the receiving entity and verification by the originating entity that all of the mechanisms that are required to be observed are set to be observed, and that those are actually in place, so that the receiving institution has the copy of the underlying work that's applicable, that security measures are in place, et cetera. And to the extent we're talking about limitation, it certainly would make sense that if the access or copying of the corpus is done for a particular research project, once that research project is completed, certainly the access should turn off, and that if it's going to be retained, then you have questions of, well, now does that entity have in turn its own ability to share the work further, which I think is very problematic. So I think we'd have to consider very carefully the limitations on the receiving entity.
Understood. Okay, Mr. Bell and Mr. Rothstein, and again, I'm sorry we keep repeating this, but if you could make your comments brief so we can make sure we finish on time.
Sure. I'll just say, I think the entire concept of research being done is a little bit questionable. There are projects that get funded, and those projects may answer one question and raise another 4 or 5 questions. In that case, having the corpus around to follow up on those is an important asset that you wouldn't want to have to go back and then respend the resources to reproduce something that you already had 5 minutes ago and then had to delete because you just came to the end of a grant period. It's just, it might fit a little bit more in sort of the sciences where you have more discrete question answer, but in the humanities, it's very important to allow those new explorations to continue.
Thank you.
So I think I'm up and real quickly. So what I'm hearing is that there would be a transmission. The receiving entity would have to keep it in order to verify research. The person verifying it, presumably, if there's a replication, would have to have a copy of the corpus. So now that's 3 entities. I don't know whether the person doing the replication would have to keep it for security. So I think this necessarily assumes that there's multiple distributions, just the way academia works. They have to maintain the research, they have to replicate, validate it, and so you have at least 3 steps, 3 distributions, which might be permanently have to be maintained based on academic standards. And that's fairly remarkable.
Thank you very much. And I'm turning it back to Joanna and Brittany. Take it away.
Brittany, you're
Yeah, sorry. Thanks, everyone. We're now going to move on to touch very briefly on some questions concerning the existing exemption. So in the comments, there was some discussion about perceived ambiguities with the term collaboration. Putting aside the requested expansion for now, is there a definition of collaboration that would clarify or clear up those ambiguities? Mr. Rothstein, I don't know if your hand was from earlier. Okay. Sure, Mr. Hanson.
It's conceivable that a definition of collaboration that sufficiently encompasses, further questions from different research groups could address this. We think that our proposed expansion actually would be a clearer way to do this. As I've mentioned, I've talked with a lot of people who are trying to implement or use this exemption, and the kind of common way that most people are reading collaboration in the existing reg is that it covers direct collaboration on particular research projects. And so you have a researcher, say, at one institution asking a question on X, and they're writing a paper and doing a project with a researcher at another institution on that very same question. And I think some of how the regulation works in practice is sort of a reflection on the demeanor and approach of the research community. I found that text data mining researchers are very detail oriented and very fastidious about following very, very carefully what the regulation says. And so if they feel like their interpretation of collaboration might be stretching the reg beyond what it could mean, and they're very careful not to do it. And I say that just as a kind of comment for how this community is reading the regulation overall. They're trying to be very conscientious and careful about it. And so they've read collaboration in a somewhat more restrictive way.
Okay, thank you. Mr. Bell?
Mr. Hanson already said a lot of what I was going to say here, because I think that we are reading that right now in this very restrictive way. But again, I would go back to what I just said about the idea that one question prompts another. And if we are trying to have a definition of collaboration, then whatever that definition is should encompass the kind of research that humanists are undertaking with these materials. And that includes that kind of relationship where one prompts another.
Yeah, thank you. Mr. Taylor?
Yes, I don't think that collaboration is so difficult in practice or in theory. What we saw was that the database creators or the corpus creators, they had no problems defining collaboration to be that work which they too were interested in, and that work which somebody else may be independently interested in. And the only real example that we had access to was KinoLab, and we explained this very clearly, that KinoLab, despite these assurances that researchers are so conservative, they in fact were very free and very able to share their works with as many people that were willing to consult with them. So I don't think that this is the issue that that the proponents make it out to be when you really look at the facts.
Thank you. Mr. Ellsworth?
Yes, I think, first of all, I don't think the regulation is ambiguous. I think it says you can't download or disseminate the corpus, but it allows for collaboration. And to me, what that leaves is direct access to the corpus as maintained by the hosting site. The other thing I just want to point out is in 1201, again, the burden is on the proponents, but there has to be a showing that there are researchers out there who were unable to collaborate. And I didn't see that in the record here. In other words, I think that this is at best sort of a hypothetical problem. It seems to me that in especially people who are very heavily engaged in this, and I think we've heard this somewhat from Ms. Sherwood, there's ways to grant access that don't involve making copies and recreating the corpus in another school. And it does require some maybe, interested researchers, but if schools aren't interested in doing that, that's not really a circumvention. And, it's not because of the anti-circumvention issue. It's really just a question of maybe resources and interest. Obviously it would be much more comfortable for copyright owners. I mean, not to go back into the whole security issue, but if we knew what was going on where and it wasn't being replicated in ways that we didn't understand.
Okay, thank you. And going very, very briefly back to Mr. Hansen.
Sure. So I think, one challenge with collaboration is no matter how you read that term, there are certain independent research questions that are just never going to fall under any sort of definition there. And so limiting to that would, unless you view like sort of the entire research academy as collaborators in a sort of grand sense, it would leave them out. And I also wanted to add that the office, I think, has seen the submission from Kino Lab, and that came up. I just wanted to make very clear in terms of interpretation of the existing reg, Kino Lab actually relies on a different portion of the reg, a different exemption, B1, the short portions exemption. And while they do use the TDM exemption, the activities that were described predate actually the implementation of the existing reg and were done under B1, which I don't think we want to get into a whole discussion about B1 at this juncture.
Okay, thank you. I'm going to call on Ms. Howard-Sukol very quickly, and then we'll move on to the next one.
Yeah, I'll try to keep my comment here short. I just want to mention that there is there are a couple other groups that are not kind of encompassed by this collaboration, right? And those are three groups in particular, right? Like TDM scholars who are at smaller and less well-resourced institutions, TDM scholars focused on non-English language text, and early career TDM scholars. And I'm going to very briefly focus on this last group to kind of show how we need something that's, I think, more than collaboration, right? Namely the existing or the expansion. So I recently interviewed approximately 40 academic scholars, librarians, and other support staff who regularly conduct or assist with TDM projects. The early career scholars with whom I spoke almost universally cited the restriction on corpora sharing as a significant and even insurmountable obstacle to their research. For instance, multiple early career scholars stated that they shifted their research to 19th century works in order to avoid copyright issues. I also know at least one other early career scholar who works on 20th century materials who won't go near the digital humanities because of the time, expense, and legal uncertainty. And there are some scholars who have started work on valuable research projects using in copyright works, and they've had to abandon those projects because of these issues. So early career scholars are choosing not to apply digital humanities methods to in copyright materials precisely because of the insurmountable challenges related to the prohibition on corpora sharing. And I just want to make sure that point is in the record. Thank you.
Yeah, thank you. I'll pass things off to Joanna again.
Thanks, Brittany. Because we're running quite short on time at this point, we're going to shift gears and ask a few questions about text and data mining generally and sort of the scope of the term. So opponents have raised concerns about the exemption being used to train a generative AI system. So putting aside the fact that both involve large digital corpora, to what extent might text and data mining involve machine learning? Mr. Bauman?
Yeah, so I have a lot to say about this particular topic because a lot of the methods so it's true that what we are using these methods for is to take measurements about culture, right? About material that's printed in books, in what we observe on TV or in movies. And so a lot of the work that we're applying are machine learning models, right? Models that can recognize where a face is in a frame and identify who an actor is in the context of that face. So machine learning models are definitely at the core of text and data mining research, I find. Now, I think the generative AI question is a slightly different one, right? In the sense that, you know, the most popular models that we see for generative AI at this point are ChatGPT, GPT-4 that can generate full text, or even video models like Sora. But it's also true that a lot of the models that we see in machine learning are increasingly generative AI in their basis, right? So even if we're not using a model to generate new text or a new movie, we're still using a generative model in the context of the work that we're doing. And to give you one example about this, you can imagine a research question that's trying to measure how predictable a novel is, right? How cookie cutter it is. And so if we want to do that, what we would do is essentially take a generative model that predicts the probability of the next word, right? Which is what ChatGPT does right now. ChatGPT uses this to be able to generate new text, but we could use that same model to measure how probable that next word is, right? If it's very probable, we have a sense about measuring how predictable it is. So even though we wouldn't be using that model to generate new text, we would still be using it to take a measurement about surprise and predictability. So I think it's important to differentiate between the use of generative AI models for doing analytical work, which I think is at the core of text and data mining, right? To take measurements about some text or about some movie, from the other kind of uses of it for generating something new, generating text and generating movies.
Okay, thank you. Mr. Bell?
Thanks. I'll just add that I don't think that we are interested in the digital humanities and recreating Sora, right? Nobody wants to make a completely generative system out of this. We're looking at those sort of analytical applications. I think that if we're talking about trying to delineate between generative and analytic uses of machine learning or artificial intelligence, it's important to note that there is that overlap that Mr. Bin was just talking about. For instance, in the project that we're working on, we are doing pose analysis of individual frames, and that involves a straightforward machine learning method where you're seeing or trying to see the poses of humans that are within the frame, but then there is something that, depending on your definition, could be considered generative because we are then inferring a third dimension that does not exist in a two-dimensional film in order to understand how those people are standing in space. And so I would just be careful about definitions excluding generative AI use that also impact the type of work that we're talking about as an accidental, side effect of trying to exclude true generative work in the sense that maybe more colloquially it might be understood.
Okay, thank you. Ms. Charlesworth?
Yes, I mean, just relatedly, I think now we've just heard that there is an overlap here, for lack of a better word. Maybe not to generate new works per se, but that a lot of the research, a lot of the materials, a lot of the data, a lot of the techniques are overlap with generative AI. And so another sort of concern here is, and I've seen this happen, where you have an academic research project and then the research or the data or whatever are turned over to another entity, maybe a commercial entity, for to exploit as generative AI material or to train AI systems. And I think even if there's no money changing hands there directly, at least, that's a concern, that we're going to have these large corpora of really, I mean, everyone's after all this data now. They're going to be sitting there, and how do we ensure if this continues, how do we ensure that that's not going to be used for generative AI projects?
Okay, thank you, Ms. Charlesworth. And now Mr. Taylor.
Yes, I think that this is a good question because I think we've had 3 years and we have a more complete record than we had before. Last time around, we were thinking that it would be only machines looking at the content that was on the record, content that was in the database. And we find out that it is not. But with the benefit of this record, we can better define text and data mining that was actually authorized in the last rulemaking to be what's I understand to be distant viewing. So I think if we incorporated distant viewing, then we would have a better idea of what indeed the Copyright Office has created under this exemption.
Okay, thank you. And Mr. Band?
Yes, I mean, the problem with using terms like generative AI is their lack of precision, as others have said. But you can imagine, even if you're sort of doing, sort of classical digital humanities research, it's going to be producing a database. Well, the database, that could be a copyrighted work, and that therefore, that's maybe generative AI. So I think we need to just not start using terms and then where we can then have unintended consequences in terms of basically shutting down this whole operation.
Okay, thank you. Mr. Hanson?
It's a very basic point, but I just wanted to go back to the text of the reg and our proposal and emphasize that sharing of the corpora outside of the limited bounds of the exemption is not allowed. And so, to the extent that there are fears, for example, of these works being, for example, uploaded into ChatGPT or kind of outside systems, the reg doesn't allow for that. And so I get it. I think that is a concern for rights holders, but it's also something that is already prohibited by the reg. As to the further definition, I think that it's really important, and text data mining researchers can chime in on this, but that they have flexibility to be able to choose their tools and the methods through which they are doing their research. I think a really quick way to make a regulation like this obsolete kind of immediately is to try to over-specify how researchers are able to do that. I think even over the last 3 to 5 years, as I've seen, that technology and the tools that people are using have changed significantly.
Okay, Mr. Bell, we'll let you go, and then we're gonna turn it to Mr. Goldberg.
I just want to confirm that the ability to choose your tools is real important. I can say that the speed with which these sort of analytic tools are coming out means that we've been running a project for the last 1.5 years, and we've changed the underlying model that we're using for our analysis multiple times just within that span, within the same project, however you would define project. So it is important to allow that freedom.
Okay, thank you. Mr. Goldberg, did you have a question?
Thank you. Yes, and Mr. Bell may have actually started to answer it a little bit. In view of the Gen AI buzzword and the discussion that it's been generating here, I was wondering if proponents could talk a little more specifically about the models that researchers are using, how they've evolved over the last 3 years, and are we actually talking about a fundamentally different activity, or do you see it as similar to the models you've already been running under the current exemption?
Sorry, thank you. Mr. Bell?
I think it's fundamentally the same activity. I think that it's just the applications that become a little bit different. The different models I was talking about are all external models. So for this particular project, we're not doing any training of new models. The new models that we're talking about are actually coming out from other sources, and we're just looking at them and trying to apply it to the corpus that we have right now. So yeah, I would say that in trying to allow that sort of flexibility of the underlying technology, we're really using the technology to answer a humanistic question. And I honestly care less about what that specific model is than about answering the question, so long as it's within the normal standards of rigor and legality and all those sorts of things for the purposes of the profession.
Okay, thank you. And we just have about 10 minutes left. We're going to go Mr. Bamman, and then we're going to move on to a new line of questioning.
Great, thank you. Yeah, so I think, again, it is important to differentiate between the uses of generative AI, right? Because we see ChatGPT now, it seems like something fundamentally new, but the models underlying it are very similar to how we've been carrying out work in machine learning over the past 40 years. Again, I think what differentiates text and data mining is that we are using models to measure something about these works and not to generate new things. Just to give you a concrete example from my own work, again, what we're doing here is measuring representation for race and gender in Hollywood movies over the past 40 years, right? So what we do, we have a machine learning model to recognize the faces in a frame. We have another model that we use to identify who the actor is that corresponds to that face. And then what we do is take measurements about how often we see men show up on screen, women show up on screen, and actors who are white, Black, Latino, Hispanic, South Asian, East Asian, to again measure how that's changed over the past 40 years. Now, we've seen increasing representation over the past 10 years in particular, but again, this is a question about measurement, right? So we're not using these models to generate any new movies. We're using the same basic machinery to tell us something that we can measure about these works.
Joanna, if there's no more questions, no more hands up, I have a quick question to follow up. I just want to clarify in particularly, Mr. Bam, in your last example, I think that what we're trying to understand, trying to get clarity on is the exemption that is provided that allows you to use copyrighted works to do text and data mining research on those copyrighted works. That distinction between using copyrighted works to train a large language model that is then applied, whether it's to these works or to other works. So I think there is a distinction there. And I think, for example, when predictability was mentioned, that is different to me than text and data mining. And I'm wondering if you could speak to that just briefly. I know we're running out of time, but there are many questions that come up here.
Absolutely. So I think that, so again, to take the predictability example as a concrete use case, there we can imagine being able to train a model that would predict, that would give us a measurement, right, about how formulaic a text is. That's simply a measure of the probability of the next word. Right. So if I train a model that can predict with complete accuracy what the next word is in a novel, then we have some sense about its status as being too predictable. Now, the way that we would train a model like that is a language model, right? To take some collection of text, train a model to condition on some previous sentence to predict those next words. And if we were to train a model on only texts that are in the public domain, right, and texts that are not in copyright, it would all be works that were published before 1928 that would look very different from works that are released in 2024.
So, and I'm sorry, and I apologize for interrupting, but in the interest of time, what we're trying to understand is, are you seeking to use this exemption with respect to the training of a large language model? Because I do think that is, as I think we all know, is subject to litigation in a lot of different courts right now, is subject to study under the Act. And what we're trying to understand is there a certain area here that is text and data mining, and then there is text and data mining on the copyrighted works that are the subject of this exemption, and versus the training of a large language model that might be applied to such works to understand things.
So I think that I would not imagine copyrighted works being used to train a large language model like we imagine ChatGPT being. But that said, I think that the notion of a language model, right, not a large one, is something that's still very common in machine learning to give us measurements about works. Right, so it wouldn't have the same capacity as ChatGPT right now, but it's a very similar kind of model. Right, it wouldn't, so again, we wouldn't train it for a ChatGPT scale large language model, but a language model itself, not a large one, I could see that.
Thank you. Is there, I'm sorry, I can't see if there's other hands up. If there are no other hands up, I turn it back to Joanna and Brittany. And by the way, we do know we're short on time. We're probably going to run a little bit over for everyone who is listening, and hopefully that our panelists can stay on.
Sure, thanks. So I'm going to switch gears a little bit here, that I think some people touched on this earlier a little bit. Would text and data mining be limited if researchers could not view and or annotate the copyrighted works in the corpus? Ms. Sherwood.
For our research question and purposes, they would be. So for example, our research is centered on the close-up in the history of film and television. And our researchers discovered in early marking that queer identities are not always discussed or evident by character through dialogue. Consequently, queer identity is not ones that can be easily counted by a computer or identified through text analysis of dialogue, for example. And so we ended up creating a metadata category for queer coded, which were more subtle modes of representation that were evident, particularly in early film and television. And so at least at this stage in our research, quantifying early representations of the LGBTQIA community in film and television requires a human to view to generate that data.
Thank you. Mr. Taylor? Oh, you're muted still.
Sorry, 4 years later on Zoom and I still can't use it. The point is that to the extent that that work needs to be done, that work hasn't been approved in this rulemaking as a non-infringing activity, and they haven't requested it either. Our concern is that it's not suddenly swept up by the fact that they have provided a lot of evidence with respect to that as far as their expansion. So to the very question is, they haven't brought forward enough examples or made the argument that that example is, and the last recommendation clearly excluded that possibility.
Thank you, Mr. Bannon.
Yeah, so I think on this point, it might be helpful here for me to talk about how we carry out this kind of work in our secure environment and the kind of complications that have for this kind of verification of results. Because all of our work at Berkeley is done in a secure research computing environment that protects data to the level of HIPAA and FERPA standards. Now, this environment is command line only, so we can't view anything in this environment. We interact with it only through text. Now, the current regulation allows for a provision for viewing the results for verifying the research algorithms that we apply on it. It's ambiguous, though, from my perspective about whether or not we can take our materials out of that secure environment for the purpose of viewing. So what we do to be able to verify the accuracy of our algorithms is to digitize our DVDs twice, right? To circumvent TPMs twice using two different exemptions, right? The TDM exemption for running computation over the entire movie in the secure environment, and the short portions exemption to sample individual frames, right? A small number of them that we can view, annotate with a human to create a measure of what the truth is, to then be able to compare those two derived metadata, right? The different spreadsheets that we create by humans and in the computational environment to see how much our methods are actually correct, right? To verify those results in that way. So I think having some clarity about what the viewing what is permissible viewing wise, I think would be helpful here. I think because of the ambiguity, we have to resort to effectively creating twice as much effort in digitizing these works twice to make use of these two different exemptions to allow us to verify our results in a way that we're comfortable with at our risk level.
Okay, thank you. So I'll hand it back to Joanna.
Okay, thank you. And this is a related question, and bear with me because it's a little bit long in its lead up. But related to the viewing of the underlying works, the current regulatory text permits the person undertaking the circumvention to view the underlying work solely for the purpose of verification of the research findings. The 2021 recommendation described this provision as, and quote, a limitation that researchers may not use the copies of the copyrighted works in the corpus for their expressive purposes, end quote. So there appears to be some tension between the two statements, where the regulatory text permits viewing, but only for verification purposes, but the recommendation prohibits viewing for expressive purposes. So our question is, should the regulatory text be revised to prohibit viewing for expressive purposes rather than to limit viewing for verification purposes? And Ms. Charlesworth, I will start with you.
Yeah, so one sort of quirk in the regulation is it refers only to the person doing circumvention, but I assume that there are other people who have access to the corpus, and so I think that needs to be clarified that whatever the rule is would apply to all of them. But second, I think the rule allows viewing for purposes of verification of the research results, which would be, you know, was this word really on this page? Was this, is this, you know, like, in other words, looking at it not for the actual content, to analyze the content, which is what is, in my opinion, is going on in some of these, at least from the letters that were submitted. People are doing close analysis of films by viewing things. I think we've heard some discussion of why that is, or why, you know, why another exemption might apply. But the point is, for purposes of this exemption, really the only viewing would be just to confirm whether you call it, like, we propose some language, but whether you call it statistical or computational or statistical results, that's really, I think, the point here. The point is you're not using this as a substitute to have human people reading the works.
Okay, thank you. Ms. Hartsuko?
Yeah, thank you. So first, I want to say that expressive, changing that to expressive would be much more helpful, and I'd like to provide an example from my background, right? So at the outset, and other researchers have said this before, but I do want to reiterate that the tools and methods that researchers use will be dependent on the needs of the project, right? These tools and methods will necessarily vary based on that project. So in some cases, properly tagging and preparing a corpus for computational analysis depends on human analysis of snippets of corpus content. This work is integral to verifying the integrity of the corpus and TDM outputs. So let me offer, hopefully very briefly, an example to illustrate, because I do think this is really important. As a graduate student, I served as a research assistant on Alison Booth's digital humanities project known as Collective Biographies of Women, which analyzes public domain biographies authored by women. So part of my work on this project involved processing public domain works using a narrative schema, which was known as the Biographical Elements and Structure Schema, or BESS for short. So specifically, BESS contains several categories of markup that are useful for analyzing narrative events. So these would include tags related to the chronology and real world events of the subject's life. These were under the tag of the persona, narration and style. This was tagged as discourse. And then passages depicting the body and character of the persona. And this was tagged as persona description. Because BESS markup involves interpretive judgments regarding what events are happening and how individuals are described in the sample text, research assistants such as myself had to review these samples and perform the BESS markup manually. A senior research assistant or the project manager would then vet the markup for consistency. Once a critical mass of samples had been marked up using the BESS language, the senior researchers could run computational analyses to understand how women's lives are narrated across the given corpus. So in short, certain projects require that the corpus is processed and vetted by humans in a way that enables the researcher to run the necessary statistical analyses and verify the integrity of the corpus and outputs. Thank you.
Okay, thank you. Mr. Rothstein?
Yeah, I don't think we should lose sight of the fact that a human review of a copyrighted work for annotation is an expressive use. And annotations are derivative works, can be derivative works, or can be infringing if they're unauthorized. So that's an expressive use. And again, coupled with the distribution, I'll go back to it. The prior proceeding was informed by HathiTrust and Google Books, and you had none of those indicia. In fact, the reason fair use was found in those cases because you didn't have those indicia. So I don't think we should lose sight of the fact that human review for annotation is clearly an expressive use.
Okay, thank you. Mr. Taylor?
Yes, I would just say I agree with the prior statements. I think to answer your question specifically, I think the regulatory language we would have to look at it to have a final conclusion, and it's been our position that we would love to see these regulatory languages before they're actually promulgated so that maybe there could be some feedback on it. But that being said, I don't think a layperson is going to understand for expressive purposes better than they do for viewing for verification purposes. I think the latter, what you currently have, a layperson would probably understand much more readily than what for expressive purposes could mean.
Okay, thank you. Mr. Band?
Not surprisingly, I disagree. I think if you go back to the Google Books case, expressive purposes means for purposes of reading the book, or here expressive is for purposes of viewing the movie. But the kinds of uses that we've just heard described, no one's, even though you're viewing it, you're not viewing it to view the movie. You're viewing it for you're viewing a snippet for research purposes. And we just need to keep in mind that this is for research purposes. And the concern that was articulated the last time, it was all about the fact that somehow this data, that the researchers might somehow on a Saturday night sit and watch these movies instead of buying them, right? I mean, but the point is a research use is not an expressive use.
Okay, thank you. We have a couple more hands that we're going to try to get through. So, Ms. Sherwood?
Hi, I think I could give an example that will clarify the difference between what our researchers are doing. So for one of our high data generation was done by a researcher who marked 9 films and 11 episodes of television, generating 80 clips. Creating 80 clips and generating 17,000 markers on those 80 clips. That means the researcher averaged 916 markers on each piece of media, or roughly 217 markers per clip. That's 217 metadata categories per clip. And I think that is not actually like viewing for expressive purposes. That is viewing for explicit metadata categories of formalistic language. If it is possible, I had requested to share my screen earlier and I hadn't done that. I don't know if we have time.
I think at this time we don't. I'm sorry.
Okay. Thank you.
Mr. Hansen?
Oh, I'm sorry. I probably could have taken my hand down. I just wanted to point out Google Books did include expressive uses. It allowed people to view snippet views, and that's highly analogous to the kinds of uses that we're talking about here.
Okay, thank you. And Ms. Huang?
Yes, I would also like to add that the Supreme Court in Warhol also explicitly recognized that the purpose of a secondary work is distinct from the original work, and I quote, when the use comments on, criticize, or provides otherwise unavailable information about the original. Like the director show has demonstrated, the type of work that the proposed expansion is enabling is exactly to provide otherwise unavailable information about the original work, a use that the Warhol course identified as a transformative fair use. Thank you.
Okay, thank you. So it looks like we have one hand left. So I think with that, Mr. Taylor, you will get the last word.
Thank you, and I'll make it quick. What we're talking about here are not snippet views. What we have seen is that researchers will build significant databases that offer substantial clips, and these clips in their totality can equal easily 1/2 to 1/3 of the entire movie. So we are not talking about Google Books and the snippet function that we see in Google Books.
Okay, thank you. And I think that is all that we have here. So at this point, I will hand it back to Ms. Wilson.
Thank you so much. And by the way, thank you everyone who is on. We really appreciate your engagement and the information that you provided today. It is very helpful for us. Clearly, there was a lot more we could continue to talk about, but it was a really helpful discussion and we really appreciate it. We will adjourn for now, but we will be back later today with our next hearing.